You also work as an arbitrator. What does an arbitration process look like?
In some respects, an arbitration process is similar to a court process. And in effect, by choosing to arbitrate a dispute, the parties are really subcontracting the resolution of the dispute to a private judge, who's the arbitrator. The arbitrator may have arbitration rules from an institution, or arbitration rules from the local legislation governing how they should conduct the arbitration. The similarity with litigation quickly erodes from that point on. Just by way of example, one of the big differences is in English High Court practice, we have what we call the White Book, which is a large volume of bundles which are stacked high on the desk. Whereas if you were arbitrating under the rules of the London Court of International Arbitration, you'd have a set of rules which was about that thick. So the arbitrators have a huge amount of freedom by comparison to a judge as to how they will conduct the process and what they will require the parties to do and when. So it is similar, but definitely not the same.
But different. And what kind of judgments, or I know that they're called awards, do they make? Is it solely confined to monetary outcomes, or what kind of determinations can arbitrators make?
Oh, well, arbitrators, their power derives from the parties' agreement.
Okay.
And depending upon what the agreement is, the arbitrator can resolve any type of dispute. But in the context of a commercial dispute, which invariably involves money, arbitrators will, depending upon the local statutes governing their powers and the rules governing their powers, they would generally have powers to make interim orders for preservation of property, for interim payments, preservation of evidence, things of that nature, which are there to support the arbitration process and make it meaningful. Because there'd be no point in having an arbitration process where one of the parties could completely dispose of their assets to defeat the process. If that was brought to the arbitrator's attention with the appropriate evidence, then the arbitrators could make an appropriate order to freeze accounts and preserve assets.
So it sounds like a much more formal process than, say, mediation and the other ADR processes we've spoken about.
Oh yes, for sure. I mean, one of the big differences between arbitration and mediation is that the arbitrator is going to be making a decision. One of the critically important rules is that the arbitrator is independent and impartial. And in order to maintain that independence and impartiality, the arbitrator will not have any private conversations with either of the parties. Anything and everything that's said to the arbitrators must be transparent. Whereas in a mediation, the mediator can have separate private meetings with each of the parties and keep those private conversations confidential to the parties, which is a very significant difference.
It is.
So as a consequence of the fact that the arbitrator is fulfilling this judicial function, then there's a different relationship between the advocates and indeed the clients and the arbitrator. The arbitrator must always keep them very much at arm's length to avoid challenges for lack of independence and impartiality. The process itself is more formal and more akin to court process, with the arbitrators making procedural orders for the parties to exchange pleadings on particular dates or documents and or evidence, all leading towards, usually, not always, but usually a hearing, which is akin to a trial in a court action. Although arbitrators do control that trial process very effectively with time clocks.
Okay.
But also they discourage lengthy submissions and encourage the parties to put as much of their case in writing as they can.
Okay.
That generally speeds up the process and avoids delays.
It sounds a little bit more streamlined than a legal process.
Yes, I mean arbitration has been criticised for being as expensive as litigation, whereas obviously it was initially intended. It's grown out of a tradition of being a faster, more streamlined process. So the arbitrator community and the arbitral institutions have worked hard at introducing processes and procedures to expedite and control costs and avoid these criticisms by speeding it up and making sure the costs are proportionate.
Okay. And the outcome of an arbitration then, what's the status of the arbitral award, if you like?
Okay. Well, arbitration awards, unlike court judgments, have the benefit of the protection of a convention called the New York Convention, which has been signed by over 170 countries around the world. So if an arbitrator in England was to issue a final award, it has to be a final award, then that award can be taken to any New York Convention country, signatory country, and enforced as of right in that country. There are certain safeguards in terms of making sure that the arbitration has been dealt with properly and that the award is a fair determination of the issues. But beyond that, it's an award which can be enforced. And that is a huge advantage of arbitration over litigation.